if you have a default judgment against you, or you recently lost a debt collection lawsuit, or maybe even an original creditor lawsuit, you're going to want to watch this video, because I'm going to detail the options that are available to you if you do have a default judgment against you, or even if you've lost your debt collection or original creditor lawsuit. I'm going to talk about some of the things that you need to look at to see if you could potentially get it reopened, and also just some of the things that you need to keep in mind, to where you may not want to look at certain options because of the facts of your individual case. Every case can have a little bit difference, and your goals and what you're trying to do with your life might be different than what someone else is looking at doing, and you should always consider that also. So first, let's just look at when you have a default judgment against you. I get a lot of YouTube subscribers, or people who come across my videos, or people come across my website and they're looking for help. They say that they have a default judgment from a debt collector, or even a default judgment from an original creditor. So one of the first things that you can look at if you do have a default judgment, or a judgment period that you lost your case, is that you can motion to set aside the judgment. And I'm just going to read here from, so you can understand what the law says, and then I'm going to talk about it from experience, from my clients, or things that I've done for myself. So it says here, in many jurisdictions, parties can file a motion to set aside a judgment. The motion typically needs to be supported by valid legal reasons, such as newly discovered evidence, fraud, mistake, or misconduct by one of the parties involved. The court will consider the motion and may reopen the case if it finds sufficient grounds. Now, dealing with clients, this is one of the things that I've, when people come to us that want to be clients, and they've had a default judgment placed against them, and we would, review their case, look at all of the documents, see if they responded to the court summons, like, what did you say, what did you do, what did they give you, all of the stuff, because you got to look at everything. And then based off of that, we could say, well, these are your options that are available to you. And for, there's no rhyme or reason behind it. Some debt collectors, even the same debt collection company may not give all of the same evidence that they would give in another debt collection case that they have against another individual. And it could even be from the same batch of debts that they purchase. And I think that it could come down to where they just lazy, or they just forget, or whatever. No employee is perfect, but those mistakes could be utilized to get your case reopened, and to ultimately give you a chance to win your case. Because one of the things that you need to always consider if you're looking at getting a motion to set aside your judgment is that it has to be something in there that's going to allow you the chance to win. Like, when people come to us and they're like, hey, I got this default judgment, I want to get it reopened. Yes, you could get it reopened, but do you have a chance of winning? Like, is the ultimate goal for you to be able to deal with this, or is the ultimate goal for you to be able to take this case all the way up because you feel that there's something that they did wrong? And neither one of those is the wrong decision. It's what you feel that you want to do. Now, I can tell you that you don't want to have that judgment placed on you. So if you have the opportunity to potentially, have it set aside, and then tell the plaintiff attorney that you're going to want to work out a deal so you don't have that judgment placed in your name. because that's going to make it harder for you to be able to move forward. Even if you deal with that judgment, it can still make it a little bit difficult for you to move forward. Not to say that it's not paying a judgment is not worse than having a judgment that's not paid. If you satisfy it, it won't hold you back. It may ding your credit a little bit. So let's talk about newly discovered evidence. In one of the cases that we've helped an individual with recently in reopening their case, and we actually got it reopened, motion to set aside the judgment. It was for about $8,000. And we had noticed that the individual did not have the signatures on the contract that they received from the original creditor. This was dealing with a third-party debt collector. Obviously, if you're dealing with the original creditor, you can still make these requests, but they should be able to come up with those documents. If they are not, then they're not even handling the documents the way that they're supposed to, according to the banking laws. Another thing is fraud. Like I mentioned with that other client, the credit card company knew that there was fraudulent activity on our client's credit card. They had even gave a letter stating that they're looking into it and that they know that she was not in that area where those charges were made, but there was just like a disconnect between one department with another department. And you might be saying, well, why would they ever just continue on with it? I don't know why they would, but it has happened. And so if you have been in a dispute with your credit card company or with a creditor or whoever it is, and they've even acknowledged that dispute, but for some reason they still forwarded that over to a debt collection lawyer to sue you in court, and potentially you just did not know that you were getting sued because you probably thought that it was getting dealt with the company that you had the dispute with, and it just slipped through, and maybe you did not get served. Like, a lot of things can happen. Like I've seen, like, some people say everybody gets served. I've seen where people didn't get served. I've seen where they serve people at another address because they want it. In a way, I'm not saying that they're doing it, but in a way it looks like they didn't want the person to get served. Like, they wanted to set up a situation to have the individual not get served so they can get the default judgment. There could be mistakes. Now, let me tell you about a mistake. And also, I could say that this could be considered misconduct. Misconduct on a level that may not be illegal, but it could get your case reopened. And we see this happen a lot, where you might, people that are getting sued, they write their own response. And we've even had this happen with clients in the past, but we make it clear when we get their summons response back to them. We make it very crystal clear of what you are supposed to do. When you have your court summons response, you give the court a copy and you give the debt collection company a copy. But let me tell you one of the things that I see debt collectors do, and they try to get away with doing this, is that the individual will send the debt collector the response to the court summons, and they don't get it to the court. They don't give that document to the court. So the debt collection company will be like, or the debt collection lawyer will be like, we didn't get the response. And and this is how they'll do it. They'll just motion for a summary judgment. And the individual is sitting there like, why are they motioning for a summary judgment based, and they'll say in that summary judgment because the defendant didn't respond to the court summons. And this is a tactic that they use, and that they use that when the individual does not get that to the court. And that's why we made that adjustment in our instructions, like, you get it to the court, ask the court clerk what you want them to do. Some of them say they'll stamp it, and then you have a copy that's stamped and you send it to the plaintiff attorney. Some of them upload it and the plaintiff attorney will see it. They'll see the case, how it's progressing. It'll be in there for them to download. You just have to see how they're handling it in your area. But that's a tactic that they'll use. The individual will send the debt collection lawyer their response, but they didn't send it to the court, and you've already made a mistake when you do that. So be very careful. So that could be, in my opinion, it could be a mistake or misconduct by one of the parties involved. And then some of the other things that you could look at is the documents that they supplied with the lawsuit, or with their summons. Some of those documents may not match. When we've reviewed them, we've found some of the times that the debt was past the legal statute of limitations to even bring the individual to court. Some of the times we found that the debt was purchased by a debt portfolio company and it was sold to another debt collector. And inside of the contract with the original creditor who sold the debt, they said that you cannot sell it to another debt collector. They had it in there that you cannot sell it to another debt collector. And the reason why is because they don't want another debt collector who purchased a debt to do something and they don't have any connection to that debt collector, and then all of a sudden it comes back on them. The debt collection company comes back on the portfolio company, and ultimately comes back on the original creditor who sold them the debt. So you want to always scan those documents. They're going to give you any court summons that is done the right way on the debt collector side, and we've seen them where they didn't even give these documents, is that you want to see that they have the letter of conformity, which is showing how they purchased the debt and how they're managing all of the documents. This includes your private information. You want to see the bill of sale to see who actually purchased that debt, who signed off on that. You want to read it to make sure the dates even match. Some of the times we've seen where one company claims that they purchased a debt from another company, but the date that the other company purchased the debt was after the date that they supposedly had purchased the debt. So you want to look at all of those. It's something you got to sit down and you got to read through them, and you got to just look at all of the different things that they're given as evidence to build their case. And then ultimately, one of the things that you want to look at is the having them prove how they came up with the amount that they claim you owe. What are the documents that they're supporting documents for that? And then you look at the way to open the door to make them have to give you more documents to prove that amount, because they can't just walk in there and say that you owe an amount based off of one or two statements if you don't challenge it. They can do it. So I want to be clear. They can do that if you don't challenge it, but they can't do it if you do challenge it. They have to show how they came up with that amount. So now let's move to the next way that you can get it open is you could file an appeal. And that could be where there were some errors that were, well, let me read it first, and then I'll tell you from personal experience, what we've seen. If a party believes that the judgment was reached in error or there were procedural irregularities during the trial, they can file an appeal with a higher court. The appellate court reviews the lower court decision and may overturn or modify it if it finds legal errors. Now, this is something that we have never had anyone file an appeal with a higher court. We've never had that happen. Now, we've had where you can file an appeal to have it reopened in the same court. Some of the times they'll give it to another judge. But when you're looking at appealing, you have to have something that was done wrong with the case. If you don't have any information that you would be able to put in your appeal to say, hey, this was something that I found, or it's just not going to happen. And I haven't seen any where you're going to a higher court. I don't even think that this would be based on anything that's dealing with these type of lower type dollar amount civil judgment cases. But this is an option to you. You can appeal it, and you can, if you get the same result from Say they make you appeal it to the judge, or you motion to set aside, judge sticks with what they had, and then you just say, well, what's my next option? Is to appeal it, and you have it appeal to another judge or a higher court. So really, to sum it all up, what are your goals? If you're facing a default judgment, it's up to you. These are personal decisions, but you do have options that are available to you to be able to have the case reopened, because ultimately you don't want a default judgment on you. You want to look at your options to maybe be able to settle it. Let's talk about some scenarios here. Let's just say scenario number one: you feel that the case, you just did not have an opportunity to fight the case. Like, you want to be able to get all of the information. You really did not know that this civil court summons was even out there. You were never served. You don't even know what's really going on. And there's a lot of people that are out there like that. Maybe they sent it to the wrong address, whatever. You can, motion to set aside the judgment, and then you and it's going to be based on you not ever being served. You didn't know about it. You want to have your day in court. Get all of the documents from the original court summons, everything that they have as their exhibits, and then you make a determination if you want to fight the case. If you want to fight it based off of what they're presenting, and I make videos showing you how you can deal with that, or you can contact us. We can review it and let you know. If it's something that you feel that you want to fight based off of the documents that they presented, then you just need to make your response and then have your day in court. Let's just say that it was something on another scenario that you did know that you were getting sued. You just did not show up, maybe because you just didn't know how to respond. You were afraid, for whatever reason. Money is tight. You just how we are. We can avoid, just avoid it. Pretend like it's not there. You can, in that same situation, you should get all of the information, review it. This time, look at it from a different point of view of that you want to potentially do something to defend yourself in this case. And if after reviewing all of those documents and it looks like there's, you have a good chance of winning, then you should, make your response and then provide that to the court and then have your day in court. Now let's look at it from another scenario where you're just like, hey, you avoided it. You didn't want to deal with it, but you owe this debt and you don't want to go to court. You want to take care of this. What you can do is you can approach the plaintiff attorney and work out a settlement, and you can work that settlement out based on that they would not do a judgment, that they would actually dismiss the case. And so you won't have that judgment, sitting there in your name, even though it'll be satisfied. You just won't have that public record sitting there. So that would be an option that you would have available to you. And that's what we mostly see when we're working with clients, or when we're working with individuals who come to us and they had a default judgment placed on them, is that they're going to be in one of those three situations there, where they're either going to want to settle it and not have that judgment, or they're going to want to, fight even though they knew about it, but now they want to go ahead and have their information, their response prepared so they can have a chance of winning. And then the first group is where they really just did not know that was hanging out there. Now, the big thing though, that, I know I've said, about responding, about reopening and all of that stuff, but I want you to keep it top of mind that if they get that default judgment, or they get any judgment, that you cannot just disregard that, because they're going to go after garnishing your wages. They're going to go after garnishing your bank account. So this is not stuff that you just want to sit and sit there and just disregard and pretend like nothing's going to happen. It's going to open doors for them to be able to use legal means to be able to get into your bank account or to garnish your wages, and that's going to make it tough on you. So even if you're not feeling like you want to, deal with this type of stuff, you have to be proactive, because if you're not proactive, you're just going to allow them to be able to just run all over you and do whatever they want to do. And then all of a sudden you could wake up in the morning and they've garnished your bank account, or you get that dreaded letter from your employer saying that, a percentage of your wages are going to be garnished, and it's like nothing you can do. And once they start garnishing the wages, they have a lot of leverage over you. So you got to be careful, because once they start garnishing, if it's a big company where they don't really care too much about getting lump sums, all of them want lump sums at the beginning, because a bird in the hand is worth more than two in the bush. That's the old saying. So they're gonna all want lump sums at the beginning, but once they start getting payments and they see that you have a pretty secure job, where not working maybe at a fast food place or something where you're gonna be skipping around, they're gonna more than likely try to keep that garnishment order in place, because they're gonna be like, we're gonna get all of the money. So you got to be very proactive when dealing with this. So if you need help, if you got court summons, or you had a default judgment, or you want to try to get your case reopened, and there is a time limit on the time that can pass to be able to get it reopened. So if you let it go too far, you may not even have a legal option to be able to get it reopened. So you want to check with your state laws. But you can go to my website, thecreditrepairshop.com. In the live chat, type in your situation, and if you had a documents, please upload those. That'll make it faster for us to review your information and get a response back to you. We do offer consultations, where if you just want to get information about what you can do, we have paid consultations where you can speak to someone that has worked on this type of stuff before. Cannot give legal advice, but we could tell you what we've seen with dealing with clients, with their experience, our experience, and so you can give yourself a chance if you want to try to go at this yourself. You can. We have that available to you also. So the link is below. Go to my website, thecreditrepairshop.com. In the right corner in most of the websites, you'll see the live chat pop up, and then place that in there. If you need help with your credit, please visit us at thecreditrepairshop.com and click on the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. We repair credit from A to Z. That means that if you have to do some settlements so you can move forward, we're going to help you do that. And that's the way that we repair credit. We don't believe that everything, just because it's gone off your credit reports, means that it's all fixed and solved. We don't want anything to come back to haunt you in the future. So that's the way that we repair credit and increase scores. If you need your credit reports and scores, go to the website the3scores.com to grab your TransUnion, Equifax, Experian credit reports and all 3 scores. You need to know everything that's on your credit report so you'll be able to move forward. If you have debt collectors coming after you, you can stop a lot of these debt collector lawsuits if you respond to them the right way. Grab my cease and desist collection activities letter, debt validation letter, and statute of limitations letter. Yes, debt collectors are still trying to come after people that are debts that are past the legal statute of limitations to collect. So you need to understand and know how to respond to those types of debt collectors that are trying to come after you for that debt. You can end up resetting that debt. You can end up, doing something wrong when you didn't have no legal obligation to pay that debt. So the link is below this video here in the description box. I do ask for a donation on those, but it can literally save you time, money, and frustration. It's really worth it. I see a lot of people download those and use them and write back to us that it saved them from a lot of frustration with debt collectors. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.